Hi everyone, Harry here to talk about a historic indictment. People of New York versus Donald Trump, number 71543/23. Okay, so we got to see the indictment today, and the first thing about it, it's very skeletal and bare bones. So I was wondering, would there be a conspiracy charge? Answer, yes and no. More no than yes. I'll explain. Would it be a speaking indictment? No. What we basically have is just a recitation of about as little as it could be, with the dates attached, of 34 counts of falsifying business records. And he goes through them and gives each of the dates. If you knew nothing about this case and you were just coming to it for the first time, you would come away with knowing next to nothing, saying, oh, apparently there were some business records falsified. However, Bragg made a strategic decision, obviously, to try to eat his cake and have it too, because he also publishes a statement of facts, which is the much more important document than the indictment itself for telling us where he's going. But it is not part of the indictment. So lesson one about the indictment, you're going to see, I think, what's called a bill of particulars, the defendant coming in and saying, I don't know what I'm charged with. Please explain. And then a lot of the stuff that is in the statement of facts, he'll clarify. And of course, it's a bit of a pretext of emotion because Trump already knows it, but it's obviously done on purpose to have the indictment itself is like a vessel, and Bragg intends to pour content in. It's enough after a bill of particulars to sustain a challenge. It states a crime, but it does hardly anything more. Okay, but what matters is the statement of facts, the statement that the Assistant District Attorney, Chris Conroy, made in court, and the press conference that Bragg had. So, first, while the indictment itself is just these charges, Bragg certainly does, and we were looking for this, I was hoping for this, try to put it on a stronger, broader footing of an overall scheme. Indeed, the statement of facts reads about a scheme and an agreement with the head of the National Enquirer, and it's like legal language that the next thing you expect to hear is this conspiracy or a charge of conspiracy, but he holds back from doing it specifically. Let me make a legal point, which is the charge of falsifying business records. I think a lot of people know now is a misdemeanor, but it is elevated to a felony in furtherance of another crime. But you don't have to prove that other crime. I mean, you have to prove beyond a reasonable doubt it's in furtherance of another, but there was no requirement he put it out there. So Bragg, I think, chose to have a minimal kind of discharge of or weight of the indictment itself, but again, to tell us information in a statement of facts. So that statement of facts, first we hear about three different hush money payouts. One is to a doorman. This was old and news that had kind of gone away, but who said he knew of an illegitimate child on Trump's part. And then Karen McDougal, who was paid off in a catch and kill scheme, which is what the statement of facts names it. In other words, a scheme with the Enquirer to buy stories and then not publish them. And then Stormy Daniels itself. And what is clear, again, from the statement of facts, all we have from the indictment is that these are falsified business records. But what's clear from the statement of facts is it's done in order to influence the election, conceal. It's, as I've been saying for some time, it really is not the crime, it's the cover up. The whole notion is to keep people from knowing what's happening because he thinks that's necessary for the election. And indeed, a new piece of evidence in the statement of facts that I at least hadn't seen is after the election's over, he says, "Oh, it doesn't matter anymore. You know, the National Enquirer lets the people out of their non-disclosure agreements," and Trump says he, doesn't care. There's the evidence, I think, will be very strong at trial through Cohen and others that this was done for the purpose of influencing the election. All right, this may be fodder for a future discussion, but the big legal vulnerabilities that people are worried about, they should still be worried about. So he is anchoring it to campaign finance crimes, and he's going to need to show that he does both federal and state, does Bragg. And with state, there's an issue. Is it a crime because it might be preempted by federal law, which basically sets the standards and rules for federal elections? If it's a federal crime, is it not cogent or not included under state law if you're doing something in furtherance of a crime? If that crime is a federal crime, there's a very intricate and detailed set of arguments for both of these. We'll be back with them, but I just wanted to detail that they are both, in there and in play. Okay, so what happens now? I do think you'll see what's called a bill of particulars that a defendant can move, and then the government has 15 days to explain, okay, here are what the charges are. And then we're off to the races on pretrial motions, motion to dismiss, in particular, these two legal issues that I just referred to, if I didn't, completely analyze in detail, as I will. But the big point on all of these, and the other to come, I think, a change of venue motion, is they are not appealable. Justice Merchant will decide them on the merits. Let's say he rejects them, as I think he is likely to on each of them. You just proceed to trial. And if Trump is convicted, he can preserve those for appeal, in a few years. Now the time clock works against him. If he is acquitted, then he doesn't have to worry about them, because once acquitted, the proceedings stop. Double jeopardy would prevent being recharged. But we have in coming up a long period of pretrial litigation. One other point. The judge did give general admonitions to folks and referred specifically to the baseball bat picture of Trump. And the prosecutor referred to today's tweeting out by Donald Trump Jr. of the judge's daughter, who worked apparently as a volunteer on the Obama campaign. Those were raised. You didn't have the judge give an actual gag order, but did give an admonition to everyone. So that's about as mild as it could have been. But certainly Trump is now on notice. We will see tonight with his address from Mar-a-Lago if he, in fact, gets the message and avoids actual statements that could incite violence, which is the thing that the judge zeroed in on. Okay, so legally speaking, it's a pretty open-ended, bare-bones indictment that they'll be pouring facts into, could even supersede on a future indictment. In some sense, the least it could have been, but that's a strategic decision on Bragg's part, and he still has the means, given the statement of fact, to use it to plead a whole conspiracy. The actual counts themselves, just to double back there, they're simply false entries, 34 of them. Some are supposedly tax statements by Cohen because he's paid off an amount so he can pay his taxes, even though it's not business income. So those are false statements. But even entries on the ledgers of the books of both the Trump Organization and the National Enquirer. Those are false entries in a business organization. So those are among the 34 crimes as well. And that's how you get to the 34 different counts without a specific conspiracy. So it's in there, hovering there, going to be part of the proof, but not specifically part of the charges. All right, there you have it. There'll be more to tell and unearth, especially about these legal issues that are latent, after all, in the indictment, but enough for one historic day. And until we want to really go a little bit deeper, that's enough to digest, I think. So talk to you soon. And until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.